All right, I believe we are now live. Good morning, everyone. I am Delegate Janelle Wilkins, the chair of the Election Law Subcommittee, and the date is Thursday, March 10th. We are going to commence the meeting of the Election Law Subcommittee. And we will first start by taking up Senate Bill 158, which is the cross-file of HB 35 that just passed the House on third reader today. So as you all may recall, as introduced, this bill made several changes to how SBE would conduct contracts and also how cost sharing would work. Our amendments on HB 35, which now are the ones that we'd like to conform on SB 158, they ensure that there's a 50-50 cost sharing is split between the state and the local boards. It also requires the same amount of polling locations as there were in 2018 for the upcoming 2022 primary in general. And then it also adds an additional amendment that prohibits the Board of Elections from advocating for a date for the primary election that is later than July 12th. Stan, did I miss anything?
No, ma'am, you covered everything.
You may, okay. For some reason I couldn't hear you, but you nodded your head. So I think I got it there.
Yes, you covered it all.
I don't know why I can't hear you, Stan. Maybe check your, can other people hear? Or is it me?
I can hear him, yeah.
Oh, sorry, everyone, is my computer. All right, perfect. I can hear everyone now. So thank you so much, Stan. Do I have a motion on the amendments to this Senate bill?
Move the amendments.
Second.
All right, it's been moved and properly seconded. Discussion, Delegate Lasanti.
Thank you, Madam Chair. And these are the same amendments that were amended on the floor yesterday. Is that correct?
Two of them we did.
Right, but the third one
already did. The third one was a floor amendment. Yes.
Okay. Is it possible to sever those, sever the vote on those so that we do the two that were done in committee as one vote, and then the second one that was done on the floor as a third as a independent vote?
We can. Well, we're currently we already moved them, so we're actually in the middle of discussion, unfortunately. So apologies for that, but we have already moved them. So right now it's going to be an up or down on the.
Gotcha.
Forward.
Thank you.
No problem. Delegate Long.
I had the same question. One of the questions I have is if we put a hard fast date of what was it, July 22nd, I believe?
July 12th. July 12th.
And we don't have Court of Appeals hasn't made a final decision, then what?
That's a great question, Delegate Long. The bill doesn't prevent the Court of Appeals from taking, as amended, doesn't prevent them from taking their actions. It just simply ensures that the State Board of Elections does not go ahead and lobby for a date that is later than July 12th. This is a power that we provided to the State Board for the State Board to be able to lobby in these emergency situations. And we are now curtailing that for this upcoming primary.
Right. Let me ask that question one more time. So if the Court of Special Appeals does not have a rendering or have a decision by, let's say, July the 10th, what happens then?
Well, we are expecting, the courts have indicated that their decision is going to the courts have indicated that they're expecting their decision to come out very soon. So we don't really see that as an issue. And again, the courts can still take their action. There's nothing in this bill that prevents the courts. If they decide July 30th, if they decide September 10th, the courts are able to make any decision that they would like to make. And ultimately, it will be up to the courts.
Okay, so it still gives the flexibility if it goes past that date that the primary could possibly be moved, correct?
Correct, by the courts, correct.
Okay, all right, good enough.
Stan, did you want to add something?
Just that, yeah, I mean, if in the unlikely event that the decision hadn't been made that late, Delegate Long, I mean, the primary would have had to have been delayed, and then the court would have so ruled. They wouldn't let it remain in limbo that long.
Okay, well, as long as the courts have the final decision, that was my only concern. Thank you.
Thank you, Delegate Long. And yes, to confirm for everyone, the courts have the final say in the final decision around the primary date. Any other discussion? All right, hearing none. All those in favor of the amendments to Senate Bill 158, please say aye. Aye. Any opposed? Okay, Delegate Lasanti is the only opposed that I see. All right. So on SB 158, as amended, may I have a motion?
Move favorable.
Second.
Wonderful. All right, it's been properly moved and seconded, SB 158 as amended. All those in favor, say aye or raise your hand. Give me some indication.
Aye.
All right, any opposed? All right, SB 158 as amended moves forward unanimously from the committee as amended. Subcommittee, that is. Wonderful. So moving on to HB 328, elections, polling place restrictions repeal. You all remember we discussed this bill briefly, I think 1 or 2 weeks
You're
ago.
going in and out?
Am I going in and out?
Yes,
guys
you are.
All right, let me bring my computer closer. Do I sound better? Okay, hopefully you can hear me. Just yell out again if you can't hear me. House Bill 328 is in regards to polling place location restrictions. I don't believe we have any amendments to this one, Stan. Oh, Stan, I can't hear you.
Yeah, sorry, that was my fault. Yeah, this bill does have an amendment. The amendment does two things. One is it allows the state board to adopt regulations relating to the use of a building that holds an alcoholic beverage license as a polling place, and it also makes the bill an emergency bill.
Okay, so state board adopts regulations and then it makes it an emergency bill. Perfect. Do we have any discussion about the amendments to this bill? Does anyone have any questions about the bill? So why don't we move the amendments? May I have a motion?
Move favorable on the amendments.
Second.
Second.
All right, all those, well, it's been moved and properly seconded. Is there any discussion on the amendments? Hearing none. All those in favor of the amendments to House Bill 498, raise your hand or say aye. Give me some indication. Bob, how would you like to be? Okay, aye. Any opposed? Seeing none. The bill is now amended, House Bill 498. Now on the bill as amended. Can I entertain a motion?
Move favorable.
Second.
All right, it's been moved and properly seconded. Any discussion on HB 498 as amended? Hearing none, all those in favor of HB 498 as amended, raise your hand or say aye.
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 Right, any opposed? All right, with no opposition, House Bill 498 passes our subcommittee unanimously. Okay, so moving forward, and I'm sorry, I think I was saying that was 328, sorry.
Yeah, Chairwoman, right.
I'm moving through, sorry. So just for the record, for everyone that's listening, everyone in the committee, that was House Bill 328. I moved down in my notes a little too quickly. Okay, moving forward, House Bill 498, Election Law Campaign Finance, Protection of Contributor Information. This bill prohibits the use or publication of contributor information from a campaign finance report or statement for commercial or solicitation purposes. Do we have any questions about this bill before we entertain a motion? Stan, were there any amendments on this one? I don't see any in my documents.
No, ma'am, no amendments.
Okay, Delegate Griffith.
Thank you, Madam Chair. So, commercial so prevents it for commercial solicitation, correct? Or any solicitation.
Commercial.
Okay,
Commercial.
got it. Thank you.
Can we unpack a little bit more what the commercial solicitation might mean, either Stan or Jared?
I think maybe Jared could elaborate a little better than I could on that.
Sure. Thank you, and thank you, Chair. This is basically, and this is modeled after the federal legislation. It's been there since the 70s. Commercial solicitation basically means, I would say, like if it was like Tide, we get people that constantly ask for all your contributor data so that then they can market certain products to them later on. And right now we cannot prevent that from occurring. So what this is basically saying is that if you're, trying to, sell products to your contributors, that they can't use the data that's publicly available online for that information. You can still use it. You can go through it and look at it. There's nothing wrong with that. There's nothing wrong with academics looking at this as well, but it's just to prevent your contributors from getting unwanted solicitations, about products that they never signed up for.
Got it. Thank you, Jared. Any questions? All right, can you entertain a motion on House Bill 498?
Move favorable.
Second.
Right, it's been properly moved and seconded. Any discussion?
Chair,
Yes,
Hello?
Elliot? Yes.
there's something wrong with your computer. You keep going in and out. You're loud 1 minute
Okay.
and you might want to check into it anyway. Thank you.
I appreciate that, and sorry, everyone, I don't have another computer here, so hopefully we can struggle through, and if you need me to repeat anything, let me know. The joys of technology, but sorry about that. All right, so it's been moved and properly seconded. All those in favor of House Bill 498, raise your hand or say aye.
Aye.
Okay, any opposed? Seeing no opposition, House Bill 498 passes. One more, we're moving through so quickly. All right, House Bill 862. This one is a tad bit more complex, but it addresses a very important issue. So I think we can work through this one a little bit. So House Bill 862 looks at changing the requirements when one or more absentee ballot is received. So what happens under current law is that if two absentee ballots or someone votes absentee and they go in to do a provisional, both of those are rejected. And we saw, obviously this person wanted to vote, they wanted a vote to count. And a lot of times when it comes to absentee ballots, it's an honest mistake. And during the 2020 election, the Board of Elections had a policy of ensuring that one of those ballots would count. And what we want to do is codify and solidify the ability of someone to have one vote count. So the approach that the amendment takes is ensuring that the first received legally sufficient ballot would be the ballot that would be counted. So before I go to Mike, I'm going to ask Stan to just explain and unpack that for us a little bit more, so that everyone can just understand what we mean by legally sufficient ballot. And Delegate Griffith, excuse me.
Sure. So basically the concept of it is that it would be the first received, but only if it was legally sufficient. So, an absentee ballot, if it was not signed, is not legally sufficient. A provisional ballot would not be legally sufficient if it was found, for example, that the person was not actually registered to vote or was otherwise not qualified to vote. So it would be the first legally sufficient ballot that was processed. In almost every case, that's going to be the mail-in ballot, because mail-in ballots are canvassed first. The provisional ballot canvass happens the second Wednesday after the election, but it's possible that it could be the provisional ballot if the mail-in ballot comes in very late after that second Wednesday. So this amendment is meant to cover every potential scenario of multiple ballots in a way that's administratively feasible for the local boards.
All right, thank you, Stan. Delegate Griffith.
Thank you, Madam Chair. My concern with this bill is, and I think we've made this, a few of us made this argument before, excuse me, that, if someone has a mail-in ballot appear, but they show up to the ballot box in person, I certainly feel that it should default to the person actually physically being there to vote. And what happens in the case where the individual says, well, I never mailed a ballot in, but I'm here to vote now? What happens in those situations?
Maybe I can just answer one part of that question, which is that the current policy right now is that if you've requested a mail-in ballot and you show up to vote in person, you will vote provisional. And then that provisional vote would count if you didn't send in the mail-in ballot. That's current policy. That's the way it works currently.
Does that get caught up in the fact that, and I believe we passed a law last year that an individual only has to request a ballot one time and they will get them mailed to them in perpetuity, right? So if somebody doesn't necessarily understand that I ordered one this year and 2 years from now, one just shows up because of that law, wouldn't that create conflicts down the road? Now you're gonna have more and more people showing up at the ballot box who requested a ballot in previous years, not knowing they're gonna receive a ballot every year and not knowing that's gonna force them to vote provisional.
But there's a notification, I believe, when you sign up for the permanent absentee list that's the case, that if you choose to vote in person, that it would be a provisional ballot. And I mean, that happened in 2020. A number of people chose to request a mail-in ballot, but ultimately showed up in person to vote. They voted provisional. That's just the current policy.
So, and I'm sorry, I don't want to hold everything up here, obviously, but so I have a mail-in ballot show up, but then I show up to vote. The mail-in ballot's already arrived, but I want to show up to vote. I can vote provisionally then, or it defaults to the mail-in ballot no matter what.
You can vote provisionally, and if you don't also vote the mail-in ballot, the provisional vote will count.
So if I'm sorry, I'm not that smart. So if I do both, it defaults to the provisional ballot in person.
All right, so the question is a separate issue between requesting the mail-in ballot and actually voting it. So if you simply requested it but don't vote it and then show up in person, you will vote provisionally and your provisional vote will count.
Okay.
If you vote both the mail-in ballot and the provisional ballot, that's a different story, and that's what this bill deals with.
Right. So if I vote, if I have a mail-in ballot show up and I show up to vote, the mail-in ballot, even what if I dispute? What if I say I did not mail a ballot in, but I'm here to vote now? What happens in that scenario?
You vote provisional. You vote provisional, and the provisional vote will count if you did not also actually vote the mail-in ballot.
What I'm saying is, if I state a mail-in ballot arrived, but I state I did not vote by mail,
then you will vote provisional.
okay. So I have
anytime
the ability to dispute the mail-in ballot. is what you're saying.
You will, any person who shows up in person to vote will be allowed to vote provisional, period.
Okay,
And then the question of whether it counts or not depends on whether you vote, whether you actually mail in the mail-in ballot. But you will always, if you show up in person, you will always have the right to vote provisionally.
what I'm asking though is if a mail-in ballot arrived for me, was sent in, and I dispute that is my ballot. I say, well, I did not mail a ballot in, I'm here to vote. Will the ballot that I say was not mine still count?
I'm just gonna jump in here, Delegate Griffith. It will be provisional. If you have requested a ballot, you will have to, and you go in person, you will have to vote provisional. Even if you go up there and you say, well, I didn't vote it, I didn't want it, whatever it is, you will have to vote provisional.
No, I absolutely, Madam Chair.
Maybe we're not understanding your question, because it sounds like you.
Sure. Let me try to rephrase. I apologize.
Okay.
I appreciate the patience here. So if I go to vote and a mail-in ballot arrived in my name, right? And I say I did not mail in a ballot. Yes, according what you're telling me is I will still be able to vote provisionally. The question is, at that point, which ballot will be counted? The one I'm disputing was mine versus the one I actually physically voted for in person.
Under this bill.
Be part of the canvas of the provisional ballots, but maybe Jared or Mary could answer that. I'm sorry, Madam Chair.
Sure. I guess there's two parts to this, right? One, under this bill, it would be the mail-in ballot that would count. Because
That would supersede.
Okay.
Because it would have, if it arrived earlier and before the actual canvas of the provisional ballot. Current law is, if we want to just do current law, right now, if a mail-in ballot comes in and a provisional ballot was cast, both are rejected.
Correct.
So I guess the thing is, right, so under the current process, if you request a mail-in ballot, it is then logged into your voter profile. So if you show up at the polling place, that profile is going to show that you have requested said mail-in ballot. That is why you're going to get a provisional ballot. So, you can dispute that you requested it or not. It's been logged in. You would go in there. If, at that point there, then if no mail-in ballot comes in, that provisional ballot is then cast and counted, right? That's current law. If the mail-in ballot comes in, right, during the canvass for mail-in ballots and for provisional ballots, if both are there present, right now under current law, both are canceled. They're
Right.
both rejected. So
I guess my question is though, say I show up and I say, and it's showing there's a mail-in ballot that was sent in, and I'm saying I did not mail a ballot in. I guess I'm actually looking for the opposite. I agree both ballots should not be canceled. But what I'm looking for is I would rather, in that scenario where there's a mail-in ballot and an in-person provisional ballot, of the two, the seniority should be the one where the person's physically standing there voting, not the mail-in one where that person that's there to vote in person is disputing. You see what I'm saying? I agree with the bill, just I think the priority should be the in-person ballot, not the mail-in ballot.
I guess the only problem with that then, I'm sorry, Stan and Chair for jumping in on this here, is that the mail-in ballot canvas begins prior to the provisional ballot canvas, as Stan had mentioned earlier. So if we have that, we're going to look at it and say, this is a legally sufficient ballot, right? We are then just going to, under this process here, open it and then scan it and push it through. By the time we get to the provisional ballot canvas, we have already scanned that ballot through. So that's why you want to go with the first legally sufficient ballot received.
So what's the recourse under this bill if I dispute the mail-in ballot?
What do you mean by disputing it? Meaning
if
that
I'm
you
saying
don't have to count?
if I was to show up to vote and I'm told that I've already voted through a mail-in ballot, and I say, I didn't send a mail-in ballot in, I'm here to vote today. What happens in that scenario?
I think then you would go to the state prosecutor's office with that and to see if there was identity theft, mail fraud, any sorts of, I mean, there's, I would say, a litany of the other things there, because either someone stole your ballot, tried to use your identity, but I would say that there's other prohibitions on the books currently that would deal with that outlier of a situation.
All right. So thank you for allowing me so much time to unpack that. I appreciate it. Thank you for answering my questions.
No problem. Thank you, Delegate Griffith, for the thoughtful questions. Delegate Feldmark.
Thank you, Madam Chair. And I think, just a couple of things I wanted to add to that conversation. One is, as the need for this bill came up, when I first learned that folks who may vote a provisional ballot because they're concerned their absentee ballot may not have made it, or they forgot they sent it, or a spouse who was trying to be helpful dropped it in the mail and they thought they lost it, or any range of reasons why someone may end up voting a provisional ballot after a mail-in ballot was submitted. They're basically trying to make sure their vote counts, and in the process, inadvertently canceling their vote, right? So we wanted to make sure that we could correct that. We're one of the only, and I think maybe someone from Board of Elections can correct me, or Catherine may know, but I think when this issue first came up, it was Maryland was the only state, or one of only a couple states where that was the case, right? Where votes were actually getting rejected because of this second ballot. So we want to make sure that each person gets one vote, right? And that one vote counts. The other issue, besides the sort of administrative side of when different types of ballots are canvassed, is this is a really rare occurrence, and we don't want to create the opportunity for a do-over, right? Like, once you vote, you voted. You don't get if you choose to vote by mail-in ballot, then your vote is cast. At that point, you don't get the option to go change your vote by voting a provisional ballot, right? We don't want to create sort of the invitation to try to revisit your vote once a ballot has been cast. So,
Madam Chair, can I ask a quick question of Delegate Feldmark on that?
Delegate Griffith, go ahead.
Thank you very much. Do we, and for you, maybe for Jared too, because 2020 probably the worst year for this. Do we know how many times that you had that ballot rejection because of the double vote in 2020?
well, in 2020, they weren't rejected because of the emergency provisions, right? The emergency regulations corrected this. Now what we're doing is saying the emergency regulations have expired, so now we need to fix it in statute.
Well, you just mentioned this is a rare occurrence. I guess the real question is, how many times does this happen in a given year? Is it, rare, like a couple hundred? Is it a couple thousand, like 10, ballparkish?
I would have to go back to 18 on that stat. I'm sorry, I don't have that in front of me because 2020 was kind of like the outlook of how this kind of started here. But I would say, if I remember distinctly in both those, it's not over 100. I would say that it's definitely less, but I don't want to. I'm sorry to say that I'll try to find that stat right now, but I'll get back.
Okay, Delegate Feldmark, did you have anything to finish up your thought there?
No, that was the main point, just making sure that there was that other reason why we don't want to kind of create the invitation to vote a second time.
Right. Thank you for that. Let me pause for a second. I just want to make sure all of us understand the various scenarios and how it would work under this bill. So first scenario is that hopefully someone gets their mail-in ballot, they return it, and that's the end. Another scenario though, someone gets their mail-in ballot, they return it, maybe they forget, as Elia Feldmark said, maybe their spouse trying to be helpful or something like that. And if for some reason it's mailed in, they don't realize or they forgot, and they try to vote in person. And folks can jump in. I want to make sure I'm getting it right so they're all on the same page. In that scenario, it'd be a provisional ballot, but the first legally sufficient under this bill would most likely be the mail-in, because that is canvassed and counted first. So in that period of time, though, maybe the person doesn't have their signature on the ballot, and they have the opportunity to cure it. But even in that situation, it sounds like the first legally sufficient would be that mail-in ballot, and that's the one that would count. Correct? Okay, so I think we're all on the same page with that. Mr. Demarinus.
Madam Chair, I just wanted to say, in the 2018 general election, 64 people voted more than one ballot. And that represented a little bit, close to 3% of all the rejected ballots for mail-in ballots. So like I said, it was definitely under 100. So my ballpark was kind of right, but as you can see, it's about 64 people that was in 18 that was rejected. Thank you.
So very minimal. And Delegate Lasanti, I see you there. I just want to go through if there are any additional scenarios that we should talk through. I just gave the scenario of someone voting the mail-in and then showing up. Are there other scenarios or other aspects that we should talk through as well, and how this bill would work?
I think it probably should be mentioned that this bill also deals with the issue of multiple mail-in ballots being submitted, and it just applies the same rule. The first legally sufficient received is the one that would count.
Okay. So the scenarios are basically you vote your mail-in and you show up in person, or you vote to mail-in somehow.
Madam Chair.
Yes. Well, actually, Delegate Lasanti did have her hand up for a long time. So let me go to her first.
That's okay. That's okay.
You.
Thank you, Madam Chair, and thank you to the sponsor. I mean, I think the real important piece here is that under current law, if by chance you were to cast a ballot, mail in a ballot, or like under any of these scenarios, and then go in person, not realizing that that ballot had been mailed, that your ballot doesn't count. So a person is and that's, I think, the most important scenario is somebody has made 2 attempts to vote and nothing counts. So, and I think the provision that really protects the voter in this bill is that the first one that is legally cast, it's the one that is sufficient. So I think that it's a very important piece. And look, there's a little bit of, I think, public education that has gone along with this, because we've gone from a scenario under the executive order and everything where all these ballots were mailed out. So people were getting used to a new system. And I think that this bill goes a long way to making that more a part of our everyday life. So thank you to the sponsor.
Thank you, Delegate Lasanti. Delegate Long.
The question I have is, in 2020, during the election, how was it dealt with if you had a mail-in ballot showed up, it was a legal ballot, and then you went and voted provisional? Since we were under emergency order, how did they treat those?
I can answer that.
Okay.
We counted the first ballot we received, the mail-in ballot, because we had started the canvass early. For the 2020 general election, where we had in-person voting as well as mail-in voting, we had started the canvass early to accommodate the influx of all the mail-in ballots. And so it was still under the emergency regs, and that we counted the first legally sufficient ballot received.
Okay, thank you.
You're welcome.
All right. The other aspect of this that I do want to talk through, is I think it's really important, is making sure we want to ensure this to prevent this from happening, especially with the addition of our permanent mail-in list, that voters are getting the adequate notification and reminders. So I wanted the Board of Elections to talk through. I am a permanent mail-in voter. I'm very proud of that, which I signed up for immediately when it became available last year. And I have gotten a notification a week ago from the State Board of Elections reminding me that I am a mail-in voter. They put my address and also where I requested my ballot to be sent, reminded me that I'm registered with the Democratic Party. It lets me know this is correct. I don't need to do anything. And that if the information is changed, they provide if my information has changed, they provide how I can go ahead and make those changes. They let me know my ballot will arrive 30 to 45 days before the election, and I can check my status with the link. And there's more information about the upcoming election. So I did get this notification as a mail-in voter, and I wanted to see, are there additional follow-ups, or I'll just get my ballot in the mail? So I just wanted the State Board to just remind us how we are making sure that voters are aware if they're signed up to get their mail-in.
Jared, do you have this or you want me to take it? So good morning, Madam Chair, Mary Kramer Wagner, State Board of Elections. So yes, you will continually, I don't know what method you picked. You're able, when you become a permanent absentee I too became a permanent absentee. You pick it by text, by email, or by mail. So you will continue to get those notifications. Your ballot has been sent. Your ballot has been received. So depending upon the method, you will continue to get those. And then you will also, I believe Stan touched on this earlier, you will also receive future correspondence saying you still are a permanent absentee voter. And I believe those, Stan, correct me if I'm wrong, goes through the 2022 and 2024 election cycle.
I think if you're on the list, it continues in perpetuity unless you're asked to be removed from the list or don't return a mail-in ballot for 2 election cycles, as I recall. But the applications for mail-in ballots will be sent out. Were sent out this year and will be sent out in 2024 to all registered voters.
Right. Thank you, Stan.
Sure. Thank you.
All right, so folks who have signed up, they get that reminder. What about people who they're not permanent voters, but they just requested an absentee ballot? Is it just that the ballot just sent to them? Do they get any sort of reminder or notification? How does that work if you're not on the permanent list, but you just requested one for this year?
Unless Stan or Jared wants to take this, they too get notification.
Okay.
Yes. We
Perfect.
ask all the voters for their preferred method of contact.
I can verify that because one of the other analysts on Ways and Means requested a mail-in ballot just for this year, and he showed me his email very proudly the other day from SB.
Thank you, Stan.
Wonderful. Well, I think we have talked this bill through thoroughly in terms of the various scenarios and how it would apply. Is there any additional questions, thoughts, comments on HB 862 before I entertain a motion? All right, is there a motion on HB 862? Maybe Delegate Feldmark has it.
Move favorable.
Oh, on the amendments, sorry, on the amendments, we'll take that as a move favorable on the amendments.
Second.
Is there a second? All right, it's been moved and properly seconded. Any comments or discussion on the amendments? Hearing none. All those in favor of the amendments to HB 862, raise your hand or say aye. All right, any opposed? Delegate Long, how would you like us to record you on the amendments?
I'm all right with the amendment. Wait a minute, no.
Okay.
I'm good with the amendment.
Okay, we'll have you in the yay for the amendments. All right, the amendments pass. They've been added to HB 862. So on HB 862 as amended.
Move favorable.
Second.
All right, it's been moved and properly seconded. Any discussion on HB 862 as amended? Hearing none, all those in favor of HB 862 as amended, please raise your hand or say aye. All righty, all those opposed?
Opposed?
All right, I have Delegate Griffith and Delegate Long opposed to HB 862 as amended. All right, as the speaker says, that ends the work at the desk. I think we have covered all of the bills that we had for today. We will meet next week. Things are going to be moving a little quicker as we're getting through to a crossover. So we'll try to send the amendments out as early as we can, but Stan is working as quickly as he can to get them through, along with the other subcommittees that he's staffing and working with. So we'll make sure we have time to talk everything through so that everyone's comfortable. So with that, if there isn't anything left for the good of the order, thank you everyone for the thoughtfulness and the great discussion and questions. And I'll